at this trial will show that all apps suffer from the same anti-competitive practices, resulting in anti-competitive effects. Second, it ignores that Epic does more than just develop, publish, or distribute games. Epic witnesses will testify that Epic is a developer and publisher of game and non-game apps. The developer and publisher of a world-renowned set of software tools used to make game and non-game apps, and the developer and owner of an app store that distributes game and non-game apps. Let's look at a slide that shows a demonstrative example of the types of apps distributed by the Epic Game Store, including a store within a store, that's the digital storefront, the music app, Spotify, a radio app, a 3D modeling app, and a web browser, all available today on the Epic Game Store. The evidence will show that Epic's business is varied. It is a developer of games and non-game apps. It makes software tools for the development of commercialized game and non-game apps, and it distributes both game and non-game apps. The evidence will show that Fortnite itself, something that Apple has repeatedly characterized as a game and merely a game, is far more than that. While it has competitive gameplay in Battle Royale, it also has a portion of the app that is solely for social gathering called Party Royale, which has no competitive gameplay, and the portion that is solely for user creation called Creative Mode, which has no competitive gameplay. Fortnite hosts concerts, and it hosts films, among other things. In addition, Epic has also developed an alternative payment processing solution to Apple's IAP, Epic Direct Pay. All facets of Epic's business are here challenging Apple's practices, but Apple's experts have focused on only one, limited to games. Epic also developed the Unreal Engine and companion iOS apps for developers who use it. Another point fatal to Apple's digital game transaction market definition is that Epic's claims encompass its interest in non-game apps built using the Unreal Engine. Epic has agreements with many developers of non-game apps built on Epic's Unreal Engine, and some are distributed on iOS, and they are still subject to the anti-competitive practices at issue here. Apple ignores these apps altogether. In sum, the evidence will show that when Apple focuses on a digital game transaction market, it has failed to capture the array of products made by the plaintiff in this case and in which it has an interest. Third, a game transaction market suggests that a transaction on one platform would be substitutable for a transaction on another platform. So Apple, to be correct, according to long-standing principles of antitrust economics, some appreciable number of users of one platform would need to be shown to switch to another based on price differentials between the platforms. In other words, if there was an increase in in-app purchase prices on iOS, the evidence would need to show that an appreciable number of users would undertake their desired transaction on alternative platforms, such as Android or the console or a console. But there is no evidence to support this. Apple did no study. Apple's top executives have in fact testified that they were unaware of anyone ever switching because of the increase in an app price. First, we will hear from Mr. Q.
Are you aware of anyone who has ever switched from an iPhone to an Android because they perceive there to be some difference in the pricing of apps across the two platforms?
I don't recall ever hearing that.
Is that something that Apple has studied to your knowledge?
No, I don't recall ever seeing that.
And now let's hear from Mr. Fisher, again, the head of Apple's App Store. Are you aware of any instance where the increased cost of an in-app purchase has resulted in a user leaving the iPhone, iOS world and going instead
to Android switching? No, I have not personally heard of an instance like that. Are you aware of any study that Apple has done as to whether or not an increase in price of an app on iOS could cause a user or has caused a user to switch to Android? I'm not aware of a study that has looked at that.
In order to create confusion as to substitutability, Apple points to evidence that is totally unsupportive of the necessary switching behavior. Apple points to Fortnite's consumer-friendly cross-platform functionality called cross-progression and cross-wallet. Cross-progression allows players to access Fortnite with their account across platforms and recognizes that some users engage in incremental but not substitutable gameplay. The evidence that we will adduce at trial supports this. Cross-wallet allows these users to access digital currency in their accounts across platforms. In other words, a user may have a console and a mobile device and use each of them at distinct times. At the dentist, the mobile device may be used at home, the console. The evidence will also show that Apple's theory of substitutable game transactions defies common sense. First, it simply does not work when a user does not own two different devices. If the consumer does not own an Android device or console, the Apple expert posits an even less likely scenario, where he or she would seek out a friend who would let them borrow their alternative device, engage in a transaction, and then return to their own device. Now, even when a user does own more than one device, the evidence will show that a consumer playing a game on his or her phone while waiting at the doctor's office or while commuting to work is not going to, and practically cannot, decide to make an in-app purchase on an Xbox or a PC sitting miles away at someone else's home. Theoretical switching between devices a user may not even own is without factual support. As a technical matter, the record will be full of another sort of evidence. Evidence that there are significant performance and functionality differences between the various platforms that Apple claims users substitute between. The evidence will show that the apps in the App Store, called native apps, have far superior functionality and performance to web apps and streaming apps. Apple itself ensures some of these differences by preventing web apps that are used on iOS from accessing all of the latest web technology that could result in functionality closer to native apps. Web apps cannot call on certain very important APIs, such as ARKit or push notifications, for instance, because of Apple's policy decisions. And there is latency that Apple's own witnesses recognize cause differences in performance between native apps on the one hand and web apps and streaming apps on the other. In this next slide, Apple's Eddie Q himself states that latency can significantly impact the experience of the game. The evidence will also show just how pretextual this claimed substitutability is. Apple's witnesses concede that there are voluminous differences between apps, web apps, and streamed apps, including that they are faster, they use less memory, and they can provide overall a better iPhone experience for users. Mr. Forstall testified precisely to the difference between native apps, web apps, and streamed apps.
And you believe that native apps are going to, as you say here, provide a better experience for iPhone users, correct? Correct. And looking back 15 years later, do you have any doubt that you were right at the time? No. And why do you think that native apps would provide a better experience?
I can go on and on and on for the benefits of a native application versus a web application, and they are voluminous. They are faster, they use less memory, they can take advantage of the native graphics library in a way that is either not available or would have to be shoehorned in for a web app or a different kind of application. So you can go through, and we go through for hours, the advantages.
Turning to consoles, there are so many reasons that they are not substitutable, starting with size, portability, functionality, quality, and capability of graphics and additional peripherals. You're going to see those devices here in the courtroom later today, and you will see that they don't, in fact, fit in your pocket. They can't work without a Wi-Fi connection. The Xbox and the PlayStation have to be plugged into an electrical outlet at all times for gameplay, and none is a device that people carry with them wherever they go. None of these devices are substitutable for smartphones. And finally, why is Android not substitutable? Apple itself has positioned it outside of the walled garden. iOS apps do not run on Android. Android apps are not allowed in the App Store. And the evidence will show that consumers make a choice of ecosystems at the OS level. And once having chosen, persistence within that ecosystem is strong. iOS app distribution is the rare instance of a single brand product market, but it is made by the largest company in the world, has 1 billion users and millions of developers. As Apple's own expert, Professor Rubenfeld, has asserted, iOS has played a significant role in the world's digital economy. The evidence will show that iOS is far bigger and far more entrenched in every factual way that matters than the Kodak copier at issue in the leading single brand market case ever was. The evidence will also show that Apple's claims that in the absence of IAP it will not be able to get paid are incorrect. In terms of iOS in-app payment solutions, it is worth pausing on what purchases this aspect of the case is about and is not about. This case is about purchases within the app, not purchasing transactions to acquire the app. A quick example of this IAP distinction is that of a car dealership. This case is not contesting that the dealer, i.e. the App Store, can take a commission for the sale of the car in a competitive market. Our claim is that every time thereafter the owner buys gas for the car at a third-party gas station, i.e. digital content, the original car dealer does not get to charge an extra 30% on that third-party gas sale. In this slide, we see an example of this with this demonstrative. But Apple takes a cut of every stop at a gas station after the car has been purchased, with no payment alternatives. And in this next slide, we see that what we are seeking is simply the possibility of alternative payment options at the gas pump. Apple is welcome to keep IAP as one of the options. Apple next says, well, most apps, maybe even 85%, are free. So if it doesn't get a commission at the car dealership and doesn't get paid at the gas pump, it will never get paid for its investment in iOS and related tools. And that is not what the evidence will show, and not how other OS makers are compensated. We'll circle back to Apple's plan and how it executed on the plan. Steve Jobs told developers, our purpose in the App Store is to add value to the iPhone. Free apps do that just as well as paid apps sometimes. We love free apps. Apple benefits greatly from a robust inventory of free apps. Free apps result in a more attractive app store that sells more devices. This is precisely what Steve Jobs said. And in 2016, Apple began more active sales of auction-based search. It has made very significant sums of money on such sales and a high rate of return. Apple also gets paid from the developer fees that it collects from millions of developers. The evidence will show that there is no dearth of ways for Apple to get paid. It has figured them out already. Before I conclude, let me address one final argument that Apple makes. Throughout its findings of fact and in the expert reports of Professor Rubenfeld and Mr. Malachowski, Apple argues that all of its conduct sits firmly behind the protective barrier of IP rights. There are legal arguments here that I will not get into except to say that the evidence will show that IP rights do not override competition law, as Apple's own primary witness on this topic, Professor Rubenfeld, has already acknowledged in this case. The evidence also refutes Apple's argument. The evidence will show that this argument is pretextual. There is no evidence that Apple was considering IP rights when it was drafting the terms and conditions it would impose on developers. It was concerned with the policy issue of how to build the walled garden. Apple's overreach with IP could not be clearer than this statement by Phil Schiller at a time when the App Store was already up and running, that Apple should use its license agreement as a way of protecting its ecosystem. Your Honor, Epic wants to reach customers locked inside Apple's walled garden. In the absence of Apple's restrictions, Epic and all developers will not only be able to reach those customers directly, but Epic will be able to provide them with more innovation, lower prices, and better customer service. We submit that once the evidence is in, it will show unambiguously that Apple is a monopolist, has unlawfully maintained its monopoly, and that Epic has met its burden on all claims. Thank you. Thank you. It's done. Yeah, that's fine. We don't have a jury here, so.
Our technologist needs to switch the AV, so if we may do that or take a break to do that.
I think Ms. Stone is doing that. You can hear okay? Oh, sure. It's actually better for me if you stay like this.
And I shall say
that. We have this barrier here, and the metal impacts my hearing.
You'll check the sound.
I can hear you. If you hear. Okay.
Thank you, Your Honor, and may it please the court, no parent done for Apple. Ever since the launch of the first iPhone in 2007, consumers have depended on Apple to provide a safe, secure, reliable, and quality smartphone. And because of the trust that Apple has been able to build with consumers, it has also been able to build business opportunities for millions of developers. And because of the connection between consumers and developers in Apple's App Store, millions of businesses have been launched that would not have otherwise existed. Millions of jobs have been created worldwide, and nearly a decade of economic growth has been unleashed. This case, as has just been made quite clear, is a fundamental assault on Apple's secure and integrated ecosystem, which has been what has made that tremendous growth possible. Epic, a $28 billion company, has decided that it doesn't want to pay for Apple's innovations anymore. So Epic is here demanding that this court force Apple to let into its App Store untested and untrusted apps and app stores, which is something that Apple has never done. Apple's unwavering commitment to safety, security, reliability, and quality does not allow that, and the antitrust laws do not require it. When the iPhone first launched, it was named the 2007 Invention of the Year. And as Tim Cook and Phil Schiller will tell you, not even they could have imagined then what this little device would come to mean to so many consumers and developers. Soon after launch, developers came to Apple. They already had access to consumers through the web browser, but they came to Apple to ask if they could put native third-party apps on the iPhone. And as you'll hear, at the time, there was a great amount of internal debate about Apple about whether to do this, because putting native third-party apps on the iPhone could compromise the phone itself. This is how Steve Jobs put it at the time. He said, "We're trying to do two diametrically opposed things at once. Provide an advanced and open platform to developers, while at the same time protect iPhone users from viruses, malware, privacy attacks, etc. This is no easy task." And Mr. Jobs also told people to be patient, and then Apple would work on figuring out a way to get everybody what they wanted. And Apple did find a way to get everybody what they wanted. A highly curated, family-friendly, secure, and reliable App Store. The App Store opened its doors in 2008, and since then, millions of developers, from small one-person shops to large, well-known companies, if they had a great idea and a high-quality app, have been able to seamlessly reach consumers around the world. So Apple did not create a secure and integrated ecosystem to keep people out. It created a secure and integrated ecosystem so it could invite developers in, without sacrificing the privacy, reliability, security, and quality that consumers wanted. And every day since then, Apple's business people and engineers, some of whom the court will hear from at this trial, have been charged with striking that seemingly impossible balance between two diametrically opposed things at once. Now, in this case, as you've heard, Apple's requested relief would undo everything that those engineers and business people have built, and that consumers have trusted and loved. And that is why we are bringing to this court the top executives of Apple, including CEO Tim Cook, top executives Phil Schiller and Craig Federighi, to explain to Your Honor why Apple made these fundamental design decisions and why they are necessary to protect security, privacy, reliability, and quality that customers have come to depend on from Apple. Epic is demanding that this court undo Apple's fundamental design decisions. And after counsel's opening, there can be no question about that. Epic demands that this court force Apple to allow in any and all third-party app stores so that they can distribute unreviewed and untested apps on all iOS devices. And Epic demands that this court force Apple to allow side loading, which would allow third parties to put unreviewed and untested apps directly on the device. Epic demands that this court force Apple to do all of this, which would require using its IP and making its products technically interoperable without third parties having to pay for it. The law just does not permit this, as we will discuss. From the very beginning, Apple gave developers access to iOS and the App Store, and that access was tremendous. Any developer who signed the Developer Program License Agreement, the DPLA, had access to Apple's SDKs, software development kits, containing thousands of Apple's APIs, application programming interfaces. And those are what gives developers the tools that they need to be successful. The first developer kit had 10,000 APIs. Today, there are 150,000 for the App Store alone, and that's a 15-fold increase in almost as many years. All of this has been made possible by Apple's IP. Every app in the App Store has been developed using Apple's IP. Epic knows this because the restrictions that it challenges, the provisions it challenges, specifically relate to Apple's software and the use of Apple software, tuned for their commitment to submit each app for review and approval. And that is the way that Apple is able to keep its commitment to consumers, safety, reliability, and quality, and simultaneously provide developers with enormous business opportunities. Epic, for example, has been using Apple's IP for more than a decade, since Infinity Blade first launched on the App Store. Fortnite, we'll hear a lot about Fortnite. That's Epic's signature product, as you know. It's only been around for a few years, and even Fortnite has been created and updated using 16 of Apple's SDKs, which have included thousands of Apple's APIs. Now, I've heard counsel feature-rich API like Metal is exactly what we need to bring a game designed for modern consoles and desktops to the battery-powered iPhone and iPad. As a developer, it blows away OpenGL in every way. Tim Cook has said, the App Store has been nothing short of an economic miracle. And since the App Store first opened its doors in 2008, there have been more than 180 billion app downloads. This is the kind of output antitrust laws dream about. Quality products delivered to consumers by the billions. And no one is going to dispute what this chart shows, but Epic is going to ignore it, as you just heard, because of how devastating this degree of output is in an antitrust case. Now, this chart is also devastating to Epic's case. When it comes to privacy and security, Apple dramatically outpaces its competitors. You can see their Android, which allows side loading, and you can see the dramatic difference. Epic has said that Apple failed to deliver on this. This is delivery. You will even hear Tim Sweeney, Epic's CEO, acknowledge that privacy and security are, quote, competitive differentiators for Apple. They give consumers a choice between iPhone devices and their competitors. And that choice is made possible by the very same App Store rules that Epic is demanding this court get rid of. And after what we just heard, one thing is very clear. Epic is asking for government intervention to take away a choice that consumers currently have. As you heard, also asked the court to get rid of what's called IAC functionality. And that's a feature that Apple added to the App Store in 2009 in response to requests from developers. Some history here. When the App Store first opened, developers had only a choice between paid apps and free apps. And so what game developers would do is they would offer two versions of the game. One, a paid version, which was a premium version that consumers could pay for when it was downloaded, and one for free, which was kind of a not as good version of the paid game. So developers came to Apple and asked for a new way to monetize their app. The developers could offer an app for free for consumers to download and then sell content to the consumers within the app. Apple listened to its developers, and the business model of freemium was born. And this was made possible by a complex functionality to deliver digital content that Apple called in-app purchase, or IAP. Now, game developers in particular benefited from IAP functionality. The slide you see on the screen right now is a picture of the Fortnite shop. You can buy outfits to wear in the metaverse, a glider for your rideable shark, or a backpickle or a dance. It appears here you can even buy true love, which is priceless. These are called microtransactions. And rather than one paid transaction with the developer that happens at the first download, these can happen all the time. This is great for developers. So like the App Store and its design, IAP is what the antitrust laws would consider a genuine product improvement. And it certainly was a product improvement for Epic, which has made more than $750 million on the iOS platform alone. So Apple's App Store has created tremendous output, increased choice, benefits for consumers and for developers, all of which the antitrust laws would consider a wild success. So what are we doing here in an antitrust case? Well, the answer is this. As counsel mentioned, Project Liberty, which is Epic's self-proclaimed war against mobile platform fees. What you see on the screen, Your Honor, is a slide to the Epic board from July of 2020. In the second half of 2019, prior to the pandemic, Epic had seen a meaningful decline in Fortnite. Internally, Epic executives started to discuss a business model shift, where Epic would become the middleman, paying third-party developers to develop content. But to pay the third-party developers, Epic would need to find a way to cut its costs. So, after 10 years of paying the same commission and abiding by the same rules that apply to all developers and have been in place since the beginning, the evidence will show that Epic did not want to do that anymore. And so rather investing in innovation, Epic invested in lawyers, PR and policy consultants, all in an effort to get the benefits that Apple provides for free. Epic knew that it was, quote, not sympathetic, and those are Epic's words, not ours. And as Epic's head of marketing wrote, in May of 2020, he sent an email to himself. He said they needed to create the narrative that Epic was benevolent, speaking for other developers. At the same time, Epic was writing to Apple in June of 2020, demanding that Apple provide a special side deal, side letter, or alter its contract for Epic. Epic would not have sued Apple or done any of this if Apple had just agreed to a side deal that would apply only to Epic. And as this court is well familiar, Apple did not agree. Apple refused to compromise the equal application of its guidelines. And so Epic went a step further, willingly and flagrantly breaching its commitments with Apple. And Epic's conduct in the summer of 2020 would defeat all of the affirmative defenses that Epic has to this breach, the breach to which Epic has already stipulated. As this court well knows, on August 3rd of 2020, Epic submitted to Apple a version of Fortnite with a secret and undisclosed hotfix with Epic's own payment system. And 10 days later, on August 13th, after emailing the Apple executives at 2 in the morning with their intention to breach, activated its hotfix, resulting in Fortnite's removal from the App Store. Now, even though Epic had breached, Apple told Epic that Fortnite was welcome back into the App Store, as long as Epic would comply with the guidelines that apply equally to all developers. And that offer still stands today. Now, here's something interesting, is that on August 5th, its CEO, Tim Sweeney, is writing an email to Phil Spencer, Executive Vice President of Gaming at Microsoft. And Mr. Sweeney writes, Epic has certain plans for August that will provide an extraordinary opportunity to highlight the value proposition of consoles and PCs in contrast to mobile platforms and to onboard new console users. So by August 5th, the date of this email, the hot fix is already in place. And so while Epic is deceiving Apple, it is giving Microsoft a heads up that something is coming. He is reassuring Microsoft that Epic will be creating opportunities for consoles, quote, in contrast to mobile platforms, which will help, quote, onboard new console users. So Mr. Sweeney recognizes in this email that consoles and PCs are competitors to mobile platforms, which is the exact opposite position that Epic is taking in this litigation. Here's Tim Sweeney speaking in 2012, 2 years after Epic now says Apple became an illegal monopolist. Here, too, Mr. Sweeney is saying the exact opposite of what Epic is trying to spin in this lawsuit. He says, we have a lot of platforms coming together. There are tablet platforms, smartphone platforms, computers, PC and Macintosh. And then there are consoles, Xbox, PlayStation, Wii. This is too many platforms. Over time, these platforms will be winnowed down into a much smaller set of competing platforms, according to who picks the right direction and executes successfully on them. So Mr. Sweeney recognizes all the competitors, tablets, smartphones, PCs, and consoles, and the stack of competition. Winners and losers who will be determined not by monopoly power, but by who picks the right direction and successfully executes on them. And so this is truly remarkable. Epic in this litigation is arguing and insisting, as we just heard, that this precise market in gaming transactions does not exist. And so we are all going to have to pay close attention to what is real and what has been manufactured by Epic for this litigation. And speaking of things that are manufactured, Epic paid nearly the entire cost to create the so-called Coalition for App Fairness. The coalition says things like this. For most purchases made within its App Store, Apple takes 30% of the purchase price. No other transaction fee in any industry comes close. But that's not true either. Given Epic's attack, especially this morning, it may surprise people to learn that Apple did not establish the 30%. It was Steam, another game platform, that set the 30% way back in 2003, and by the time that Apple entered the market with the App Store in 2008, 30% was, as Epic's internal documents will show, industry standard. Epic just showed us a clip of Eddie Q. But even in that clip that Epic chose to show, Eddie says that Apple was following the market. And just as those competitors who came before Apple charged 30%, so did the ones who entered the market after Apple. And this includes the Google Play Store, the Samsung Galaxy Store, Microsoft, HP, Amazon. This is the kind of market entry that is the hallmark of competition. Now, 30% was also substantially less than the typical publisher royalty at the time. Developers used to pay 70%, not 30%, and that was for shrink-wrap boxes that sat on actual shelves. And when Mr. Sweeney distributed third-party games in the 1990s, he charged 60%. And he's described that in this litigation as a fair royalty. So today, in the App Store, 84% of apps are free. It is true that we love free apps. And so for 84% of apps, developers pay zero to Apple. Many pay 15% due to reduced commissions on subscriptions and for small businesses, and the most a developer will pay is 30%. So, putting all the rhetoric aside, we are here in a bench trial in an antitrust case. And in this antitrust case, where Epic bears the burden, as counsel said, it cannot prevail, not on the law and not on the facts. Epic is wrong on its relevant market. Epic cannot show that Apple's conduct was anti-competitive. Epic cannot show that there are anti-competitive effects. Apple has a host of pro-competitive justifications for its conduct, and Epic cannot prove a tie. So in order to win this case, Epic has to run the table on this. It has to be right on all of these. And we will show that on the law and on the facts, Epic is not right on any of them. Now, every one of Epic's claims depends on its ability to define the relevant market, the universe of reasonable substitutes. And as counsel said, their economist, Dr. David Evans, proposes a single brand aftermarket of iOS app distribution containing all apps in the App Store. And as counsel recognized, Epic bears the burden of proving that this would be what the law has said is the extremely rare case of finding a single brand market. Now, the court has already said in her PI order that the proper market definition can only be determined by looking at commercial realities. So we are going to focus on those. One of our expert economists, Dr. Francine LaFontaine, who served as the director of the FTC Bureau of Economics, will offer opinions to the court about proper market definition. And Dr. LaFontaine will explain why, based on commercial realities, Epic's proposed market is both too broad in terms of number of apps and too narrow in terms of number of platforms. Okay, so to begin with, Epic's proposed market is too narrow because there are many platforms where consumers and developers engage in game transactions. PC, Mac, iPhone, Android, consoles including Xbox, PlayStation, and the Nintendo Switch, which, by the way, does fit in your pocket. Even within these devices, there are sometimes multiple options. New market entrants are coming on the scene right now. Cloud-based streaming by Google Stadia, Amazon's Luna, and NVIDIA's GeForce Now. And those are offered both through the web and by native apps. So Epic is really down on the web browser, but some of the world's most sophisticated companies are launching their newest and most exciting products through the web browser. So what this market shows is options and options within options. And again, this is what a competitive market looks like. And Epic's market ignores all of that. It focuses only on this, the iPhone and the App Store. That is Epic's relevant market. Now, to begin with, Epic's proposed single brand market is also too narrow because consumers do something called multi-homing. And that means they use more than one device to play games. So there's a bunch of survey experts in this case, and this is a result of a survey done by our expert, Dr. Hansen. We found that 95% of iOS users regularly use or could have used devices other than their iOS device, like PCs, Mac, or gaming consoles. Now, not only do consumers multi-home, developers also multi-home. They are offering their games to consumers on multiple platforms. Fortnite, just to take one example, is offered on many different platforms, including Android, PC, Microsoft, Xbox, Sony PlayStation, and the Nintendo Switch. And you can see that Apple is not such a big part of that. So as illustrated by Epic itself, Apple is not imposing any restriction on game developers' ability to reach consumers and sell their apps on as many or as few platforms as they would like. And our expert, Dr. Lauren Hitt, a professor at Wharton, has analyzed competition and substitution in the game transactions market. This is something that Dr. Evans, Epic's expert, does not test at all. This is a chart from Dr. Hitt's report. This chart, iOS is the red line, And this chart shows the majority of Fortnite accounts are not on iOS. Many are on Android or the Switch or Xbox or PlayStation or PC. iOS is typically the third or even the fourth most popular platform. Again, makes you kind of wonder what we're doing here. It also appears that when Fortnite was removed from the App Store, the red line goes down and all the other lines go up, except for the purple line, because that's the Google Play Store, and Fortnite was removed from there as well. The court will see that the same thing happened when Nintendo launched the aptly named Switch in 2018. The number of iOS users went down. So, consistent with commercial realities, Dr. Hitt is going to present both qualitative and quantitative evidence that consumers switch among gaming platforms. And in real life, even if not in this courtroom today, Epic has recognized that consumers do substitute across game platforms. Here's what they told people when they got Fortnite removed from the App Store. If you're left behind on iOS after the Chapter 2 Season 4 launch, the party continues on PlayStation 4, Xbox One, Nintendo Switch, PC, Mac, GeForce Now, and through both the Epic Games app at epicgames.com and the Samsung Galaxy Store. So it would be fair to ask Epic how they can deny to this court the robust competition in this market when this is the kind of thing that they're saying to people publicly. In addition to multi-homing, we are also going to be talking about the commercial reality of cross-platform play. Modern gaming, which this trial is going to show us, is really a thing unto itself, and it allows people to play the same game at the same time with other people on different platforms. So this slide is a picture of 4 people playing the game Need for Speed, and it highlights how absurd Epic's approach to relevant market is. One of these people is playing on the Xbox. Another one is playing on the iPhone. One is playing on the Nintendo Switch, and one is playing on the PC. So even though these 4 people are all playing the same game at the same time, 3 of these people are not in Epic's relevant market. That is not the commercial reality. The court is also going to hear evidence about something that is also very important called cross-wallet play. So cross-wallet play means that consumers can buy game currency on one platform and then spend it on another. So, for example, I can buy V-Bucks, which is the currency used in Fortnite, on any of these platforms and spend them on any of the others. And so that means if I buy V-Bucks on Android or PC or Xbox, but I spend them while I'm playing Fortnite on iOS, no commission goes to Apple. I can even buy V-Bucks through the web browser on my iPhone and spend them on purchases in the app. That's available to me. So even though I bought the V-Bucks on my iPhone, no commission goes to Apple. And cross-wallet play creates an enormous and unrecoverable problem for Epic's market definition. Here's why. The parties agree that the App Store is a two-sided transaction platform, serving both consumers and developers. The Supreme Court, in the Amex case in 2018, said that such transaction platforms are best understood as supplying one product, transactions, which is jointly consumed. So Dr. Evans focuses on app distribution, not transactions. So where are the transactions happening? In gaming, transactions, like the purchase of V-Bucks, can take place somewhere other than where the app is being distributed. And so I may be playing an app distributed on iOS, but the transaction occurred somewhere else, like on Android or Xbox or my PC. And that platform is where the Supreme Court says for one product, the transaction is being jointly consumed. And in fact, Epic's internal data show that most people who play Fortnite on iOS are not engaging in transactions on iOS. So this is a very big issue for Epic, and we've heard nothing this morning that's going to get them around this issue, and we will hear nothing throughout this entire trial that will get them around this issue. So all of that goes to why Epic's relevant market is too narrow. But Epic's relevant market is also too broad because it contains all apps in the App Store. So the App Store is a store. And like many stores, it's full of products that are not substitutes for each other. So this slide has just a few examples. Fortnite is not a substitute for Waze, and it's not a substitute for the Starbucks app. Under the law, including the law in the Ninth Circuit, for Epic to cluster all of these non-substitutes together, it would have to show that products in the store are subject to the same competitive conditions. And Epic cannot show that. As we just discussed, the gaming market is subject to distinct competitive conditions that facilitate substitution, like multi-homing across many platforms, cross-platform play, and cross-wallet play. And so this is Epic's burden to show. They have to show that clustering is appropriate under the law. And even though the court raised the issue of clustering in her PI order, Epic doesn't mention it at all in its conclusions of law. And we didn't hear one single word about this morning. And there's a reason for that. Because they don't win on it, and it is dispositively defeating for their relevant market. So just to take another real-world example of this, groceries also sell a lot of products, like bread, food, toiletries. Sometimes they even sell wine. Now, imagine there's a liquor store down the road, and maybe also a boutique wine store next door. All day long, customers are going in and out of these three stores buying wine. Customers make choices. Do I buy wine from this store? Imagine there's a liquor store down the road, and maybe also a boutique wine store next door. All day long, customers are going in and out of these three stores buying wine. Customers make choices. Do I buy wine from this store?
Orders gone out that the courtroom is taking a break. So, it looks like the courtroom's gone on a break. How's everyone doing? So, they're going on break for about 40 minutes, I believe. So, stream will still be up and running just in case there's anything after that. So, you can leave if you want, but you can come back in 40 minutes.
All
multiple
participants
artist
are
accounts
now in
and
interactive talk
managing the
mode.
payments that happen between this account and that account, managing.
All participants are now in listen-only mode.
You are muted. You can mute or unmute yourself by pressing star 6. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting. You are muted. You can mute or unmute yourself by pressing star 6.
Can't speak. Well, we can listen. Let's run the call.
You better. Yeah, moving lines, it sure is. Hiding lines,
Yeah, the kids that got through on the phone line. By the way, Monique just sent an email to everyone, but addressed to Boss, which I assume means the judge. Here's an email from Monique. But Monique is asking if, I think what she's asking is, can we shut line 3 down? I don't know. The problem is, like, say for line 3, what happens is it just spontaneously disconnected the AT&T line there. This is why I said line 3 down. I called it on my cell phone. There was no audio. So it lost the AT&T connection. It was still connected to things. So it was trying to frantically report from them because those lines were connected. So, and, you know, Monique and Buzz, I think, both said that that's possible. Like, they're not stable, so it's disconnect and not know it. I will say that that's important. Yeah, that's because I'm only, you know, I have line 3 on the phone at my desk. I'm able to hear what's actually happening with that. I don't know what's happening with the other public line. Francis' line. For all I know, that could be one where they're shouting, and they figured out how to get around it too. So. I mean, they clearly, it turned into a cat and mouse thing. They were doing it, and then I started figuring out how I could shut them down again. I kept having, like, re-enter the code to shut them down, and so then it just kept happening faster and faster and faster.
I was just going to get ready again. thanks for monitoring the public. If I see anything on Twitter, or if I see any people mentioning problems, I'll let you know. That's how I've been.
Thank you, Honor. The chart that's currently on the screen shows us the chart that is currently on the screen. Thank you, Honor. Shows us why Epic, throughout this case, is going to have to twist itself into a pretzel with disfavored theories and background to define a relevant market. In the logical market in this case that reflects commercial reality, the market for game transactions, Apple cannot be argued to be a monopolist. Now, Epic also cannot show that Apple's conduct is anti-competitive. In the recent Qualcomm case decided by the Ninth Circuit, before the Ninth Circuit even looked at anti-competitive harm, it looked to see if there was anti-competitive conduct in the first place, applying Supreme Court and Ninth Circuit precedent on duty to deal. So as in Qualcomm, this law forecloses Epic's case. The court is very familiar with the law in this area, and that law is clear that businesses do not have a duty to deal with competitors. And because they do not have a duty to deal in the first place, they do not have a duty to deal on the terms and conditions that those competitors might prefer. That's Trinco and Linkline from the Supreme Court, Qualcomm, Aerotech, and various others from the Ninth Circuit. And the law in this area, which Epic's counsel declines to discuss, is particularly strong in the area of intellectual property. Businesses have no duty to make their products interoperable or to license their IP. And amongst others, this is the foremost pro case in the Ninth Circuit. That case says that the law regards technical incompatibility, for example, the integrated ecosystem, as pro-competitive because it gives consumers a choice, like between the iPhone and the Android devices. In this case, Epic challenges Apple's technical design and contracts because they block, prohibit, and foreclose third-party app stores, apps, and payment systems. They are challenging a refusal to do it. And this slide contains a list of just some of the places in Epic's expert reports where they outright state it. And as in the Qualcomm case, very recently decided this is a non-starter under the law. The relief that Epic seeks absolutely requires forced interoperability and a compelled license. Epic has already admitted in its interrogatory responses in this case that it is virtually impossible to develop an app for iOS without Apple's IP, its API. In other words, third-party apps, app stores, and payment systems can only exist on iOS with Apple's IP. So Apple would be forced to license its IP, even to untested and untrusted apps and app stores, and to make its products interoperable with every app and app update. And I suspect you will not hear the Epic witnesses deny this, because they know what IP is required, and they know what it takes, including on the engineering front, to make sure that the products are interoperable, and that those products will work on the iOS platform. This is a case about software. Now, when we look at Epic's actual proposed injunction language, it jumps right off the page at you. And so we didn't list it out all on this slide because there's too much of it. But it is very clear when you look at the language that they are demanding in the form of an injunction, when it comes to side-loaded apps, third-party app stores, and third-party payments, they are seeking a requirement to deal, a requirement to license, and forced interoperability. We have one example on this slide where it's just undeniable. Epic is asking the court to prohibit Apple from impeding third-party app stores, payment systems, through technical means and contractual means. That means we would need to make our products technically interoperable, and we would be forced to enter into contracts to license our IP. The law just does not require that, and it does not permit it. And it is square as been held so many times by both the Supreme Court and the Ninth Circuit. The Qualcomm case, after making its findings on duty to deal, the court did turn to anti-competitive harm, and in this case as well, Epic cannot show anti-competitive effect. And here we're talking about diminished consumer choice, reduced output, and increased prices. So, as I said at the beginning, the type of output that's been brought by the App Store in an antitrust case is just astounding. Business opportunities have been created for millions of developers and spurred the creation of an entirely new industry related to app development and design. This is the hallmark of competition and what antitrust cases look at. Not only have app downloads increased exponentially, the number of users has dramatically increased. This is a chart that shows developer revenue. Developer revenue has gone dramatically up. And as output has increased, Apple's effective commissions have decreased. Effective commissions for game apps was 8.1% fiscal year 2019, and for all apps, it was 4.7%. More developers are offering apps for free. Today, that number is 84%. Epic ignores all free apps. And developers are increasingly taking advantage of monetization options that do not involve commission to Apple, which Apple has made easier to do, like signing up for subscriptions on other platforms that then you can use on iOS. As Tim Cook said recently, prices have only gone in one direction, and that's down. Apple has reduced commissions for subscriptions, for premium video entertainment, and earlier this year for small businesses, which are businesses making less than $1 million a year. In an antitrust case, no price increase ever is a big deal. And Epic likes to dismiss the small business program, but even if it doesn't matter to Epic, it does matter to a lot of small businesses. Google thought this was such a good idea that they followed us. Another sign of competition. Now, I saw council put up on the screen a chart supposedly about the App Store's margins. And they're going to pull documents out of context in this case, and this is incredibly misleading. Ethics expert, Mr. Barnes, the accountant, looks only at one segment of the iOS ecosystem. But as our witnesses will explain, Apple's business is integrated. And so Apple doesn't internally allocate to the App Store most of the costs in running the store. And let me make that very concrete. Apple's software teams, for example, do an enormous amount of engineering work, like creating those SDKs and those APIs that we talked about, that Epic says you couldn't even make an app without that. So without those SDKs and APIs, there wouldn't be any apps in the App Store. But none of those costs are formally allocated to the store, and instead, reflecting its integrated business model, Apple calculates its profits company-wide. So the evidence is going to show tremendous output and reduced prices and consumer choice, no anti-competitive effect. And in fact, what's on the screen right now is what Epic's economist, Dr. Evans, said in 2011, a year after Epic now contends our conduct became anti-competitive. He said, iPhone users have done very well, also as a result of the tens of thousands of applications they can choose from, some of which enable them to do things that were not possible before. New markets have opened for entrepreneurs. By bringing developers and users together, the iPhone has served as a catalyst, which has created value and profit out of thin air. That's quite an endorsement. In fact, it wasn't just David Evans' opinion in 2011, it was his view last year. Last year, he said, there isn't much controversy that Apple's rules have enabled it to create a high-quality app ecosystem for the iPhone. So this time, he attributes Apple's high-quality app ecosystem to the very rules Epic is asking the court to get rid of. This is the person, Your Honor, that Epic's entire antitrust case relies upon. And we are going to cross-examine him. Evidence is also going to show that Apple has a host of pro-competitive justifications for the design choices that Epic is asking this court to get rid of. Now, these are Apple's pro-competitive justifications. Consumer trust, security and privacy, reliability, quality, user experience, consumer choice, and protecting our intellectual property. Now, these may sound familiar because they are the principles that form the foundation of Apple's brand. They are the North Star and the reason that many consumers, including apparently Tim Sweeney, prefer the iPhone. To win this case, Epic would have to convince this court that every one of these pro-competitive justifications is all just a big pretext. Epic really only speaks about security, so we'll address that one. Epic's argument here is basically, why can't you just protect the iPhone like you protect the Mac? Well, Phil Schiller is going to tell you, he was there from the beginning, that even then Apple knew the iPhone was going to be very different than a PC or a Mac. To begin with, it was a phone. It had to work all the time, like when you're in a medical emergency or you're stuck at the side of the road. So reliability was priority one. And priority two was security. The iPhone keeps our most personal data, our health data, our location, our kids' location. Priority one and priority two reliability, and security. And Apple is not going to sacrifice either one of those. An ethics question, why not apply the same security from the Mac to the iPhone, shows how truly dangerous their position in this case really is. iOS devices face an extraordinary threat model. There are over 1 billion portable iOS devices with over 1.8 million apps available for download. Each device has a camera and a microphone and a GPS that are always present. This threat model is what makes iOS different from macOS. The iPhone is not a Mac. It is a rare moment when somebody leaves a Mac on a bus or in a movie theater. Your Mac doesn't always know where you are or where your children are. More devices to attack, more opportunity to attack, more incentive to attack. Take away the security, particularly to the iPhone, and the bad actors are going to have a field day, which is why Android security statistics are so much worse. Now, the way to combat the threat level to iOS devices is to have multiple layers of security. And as you heard, the iOS itself is one critical layer of security. And Apple's App Review is another. Phil Schiller and Tristan Cosmita, the head of App Review, will take this course deep inside the App Review process, which utilizes highly sophisticated AI and machine review in addition to human review. App Review makes sure that the apps perform as expected, that they don't damage your device, that they don't contain any objectionable content or malware, and that these apps are not pirated or copycatted, which is something that Epic really appreciated when App Review stopped a copycat app called Fortnite. So it is the human review that really sets App Review apart. You need people, not machines, to figure out if the app is pirated, if it contains hate speech, difficult judgment, or pornography, if it is too violent or offensive for kids, or whether the app doesn't need access to parts of your phone. And when the human reviewers spot new threats, they can get in and change the code, use the electronic review. And so these problems could be caught in the future. And so in this way, App Review is learning and getting better all the time. Now, App Review doesn't just protect security, it protects reliability and functionality of the phone, priority 1 and priority 2. It protects against bugs and malware and apps that drain the battery, things that consumers do not want. Now, when our expert, Dr. Rubenfeld, pointed out that rogue apps can hurt consumers and damage the Apple brand, Dr. Evans had this to say. He says, Dr. Rubenfeld simply asserts that there is a rogue developer who lacks incentives to protect users and developers from harm. Well, yes, rogue developers are not rational economic actors. They do lack those incentives to protect consumers and developers from harm. In security, you are only as strong as your weakest link. Bad actors only need to find one app store with weaker security in order to infiltrate the entire iOS system. Now, a substantial portion of Epic's presentation focused on some individual examples of some things that got through in the course of nearly 15 years. Each of those examples is an example of why App Review is needed. Epic's response to phishing scams is to ask a court to order us to remove an extra layer of security. So we freely acknowledge App Review is not perfect. Those individual and cherry-picked examples should be measured against these overall numbers. There are more than 1.8 million apps in the App Store. 100% of all apps are automatically screened for known malware. 100,000 are reviewed each week by 500 expert reviewers, and Apple rejects a full 40% of apps due to glitches, bugs, or because they compromise user privacy or security. And it sounded like Epic thought that was a bad thing. But consumers think it's a good thing because it makes the product better. Epic also showed you some negative quotes from surveys that Apple does of its developers. Now, those same documents contain quotes that Epic doesn't want to show you. Developers who say, I gave the App Store a high rating. I love the new design of the App Store. As a consumer, the App Store has become a really great destination. The developer process is great. Keep up the great work that led to 24-hour and less review time. Overall, it's been a great experience. Those are all from separate developers, and there are many more that I could read this quote. So the point of this is not that there are some strongly positive or strongly negative comments among thousands of developers who have been surveyed. Of course there are. The point is that Apple collects this feedback from developers, escalates all the way up the top of the chain in the company to the executives so that they can make the business decisions that will make the product better. And the proof is in the pudding. Epic is effectively saying to Apple in this case, why can't you just allow side loading like Android does? They are asking us to remove a competitive advantage. Epic wants us to be Android, but we don't want to be. And our consumers don't want that either. They want the choice. Look at this sentence from Epic's conclusions of law. They say, at most, App Review provides an additional layer of security by filtering out obviously malicious or otherwise dangerous apps. Even if this one sentence that Epic grudgingly concedes is true, this alone would show that the reason for what Apple is doing is real and not a pretext. And while Epic says at most people would think filtering out malicious and dangerous apps is pretty important. So, finally, Your Honor, moving on to Epic's tying claims. Under the law, a tie only exists where buyers are required to take a product. There are two problems with this. One is that IAP is not a product, and the second is that it's not required. As the court has already said in the PI order, the IAP system appears to be integrated with the App Store and historically to have never been a separate product. So the evidence will show that that is right. IAP has never been offered, marketed, or sold separately by Apple. It's not a separate product. And this makes sense because IAP is not a product at all. It is not, for example, a payment processor, as Epic likes to insist. Apple actually outsources payment processing to a third party, which in the United States is Chase Bank. So IAP is a complex functionality that performs various steps, including account checks, pre-sale checks, and fraud checks, to make sure that when a consumer and a developer engage in a digital transaction through the App Store, that transaction is as seamless and legitimate as possible. That transaction takes place on the device. IAP is also the most efficient way for Apple to collect its commission. As the Apple executives will explain, there are many ways to build a business. And IAP was the one that they chose to monetize the App Store because it best reflected the relationship that Apple wanted to have with consumers and developers. And it worked. For consumers, it reduces friction so that consumers don't have to enter their financial information all over the place. It means that Apple doesn't make money unless its developers make money, which aligns incentives. And it means that many apps in the App Store can be free. It helps attract more consumers to the store, which boosts revenue for all developers. Apple was not the first to do this, and it wasn't the last. There are many companies that do something similar. So not only is IAP not a product, it's also not required. It is the developer's choice how they want to monetize their app, and plenty do not choose in-app purchase. They can choose paid advertising or other promotions, and Epic knows this because it monetizes Fortnite in some of these other ways as well. The truth, Your Honor, is that Epic's tying claim is really just an attack on Apple's 30% commission that Epic does not want to pay. And if that weren't already obvious, the Project Liberty documents say this in black and white. But while IAP functionality may be the most efficient way to collect the commission, it is not the commission itself. In a world without IAP, Apple would still be entitled to collect a commission, and developers would have to pay extra for the payment processing costs that Apple now covers. Costs would go up. Those costs could be passed down to consumers, It would also confront more friction in making transactions, which in turn would be bad also for developers. So that is not a world where consumers or developers would be better off. And it's not just with IoT, but in general, Epic's requested release will harm consumers and developers. And this point can perhaps be best made by asking ourselves the question, what would have happened if Epic had been granted the release they seek today, way back in 2010, when Epic now says that Apple's conduct is an antitrust violation because of its own enforcement of its own guidelines in the Play Store? You know what did happen, reflected on this chart, based on the trust that Apple has been able to build with its consumers. But what if none of this had ever happened? Or this? Or this? And what about the next 10 years? What will Apple's commitment to maintaining the security, safety, and privacy of the App Store, to maintaining the trust it has built with consumers? What will that bring over the next 10 years? Well, Epic's requested release will make sure that none of us ever finds out. And here's another problem. If Epic prevails, other ecosystems will fall too. As the court noted in her PI order, Sony, Nintendo, and Microsoft all operate similar platform models to Apple. The court wanted to assess whether there would be serious ramifications for those businesses as well. Well, the evidence will show that there would be. We asked Mr. Sweeney if he thought that console manufacturers were monopolists in their own products, and he said yes. And it's true. If Epic can prevail on its theory, there will be nothing to distinguish any of these transaction platforms. They all charge the same commission. They nearly all prohibit sideloading or third-party app stores or both, and they all facilitate in-app purchases. Mr. Sweeney's personal preference that all platforms be open is directly contrary to what the antitrust laws say is pro-competitive. And the law protects Apple's choice to have an integrated system, just like it protects Sony and Nintendo. And so at the end of the day, Your Honor, to win this case, Epic is going to have to convince this court of so many things that don't make any sense. That the same games being played by the same people at the same time should not be grouped together. That a business model praised just last year by Epic's lead economist should be invalidated based on the testimony from that same economist. And that Apple's brand-defining commitment to safety, security, reliability, and quality are all just a big pretext. But the most dangerous thing that Epic is going to try to sell the court is the idea that consumers would be better off if Epic had its way. Nothing could be further from the truth. Epic speculates about a world where Apple is a different company, and is asking this court to make a big bet that that world is a better world than the one we live in. It isn't. The results for consumers and developers will be less security, less privacy, less reliability, lower quality, and less choice. And those are the very things that the antitrust laws seek to protect. Your Honor, we look forward to presenting our case to you.
Thank you, Ms. Gunn. Ms. Forrest, your first witness. Yes. Thank you, Your Honor. And Ms. Forrest, just give me a moment, please. Go in. Sports. The first witness.
Epic calls Mr. Timothy Sweeney.
Solemnly swear the testimony of affidavit to the on trial shall be the I think that's the truth. Let me go. Please state your full name. Solemnly swear the testimony of affidavit.
Hold on. Your mic's not on.
Okay.
Alex, try. I heard you, but we need to get the mic on.
Sorry, I'm Timothy Dean Sweeney, SWDE.
All right, thank you.
All right, good morning, Mr. Sweeney. Where do you live, sir?
I live in Fairview, North Carolina.
And where do you live, sir?
I live in Cary, North Carolina.
Thank you. And by whom are you employed?
I work with Epic Games Incorporated.
And what is your position with Epic?
I'm the CEO and founder of the company.
And did you have anything to do with the decision by Epic to sue Apple in the case that has brought us here to trial today?
Yes, the CEO of Epic, it was my decision.
All right, and without giving me any legal advice that you may have received, can you tell me what led Epic to sue Apple?
Certainly, Epic had been working on the iOS ecosystem since around 2010, and we loved it in the early days. Over the following decades, it became increasingly apparent that Apple's control of the ecosystem was increasing prices and restraining developers from realizing their creative vision. And that led to a series of conversations that Epic attempted to have with Apple executives a number of times, starting in 2016 and going onward, none of which ever really connected with Apple. We never wanted to have high-level discussions with us. And so in June of 2020, I believe, I sent a letter to Tim Sweeney stating Epic's immediate concerns in the form of several requests of Apple, which I received a reply about in July. Refusing all of them, and that led to my decision to launch Project Liberty and to confront Apple publicly.
And were there any particular Apple policies with which Epic disagreed at that time?
Yes, the terms that really stand out are Apple's...
I'm going to interrupt only when I don't have a clear understanding of something in the question. And this will be consistent throughout the trial. So are you asking him for his view as of the 2020 letter to Apple, or when Project Liberty started, which I understand to be substantially before that?
Okay. Thank you, Your Honor. Let me perhaps reword the question. Mr. Sweeney, at the time that Epic sued Apple, were there specific policies with which you disagreed?
Yes, there are two major disagreements were over Apple's policy prohibiting all competing stores from existing on iOS, and Apple's policy requiring that all payments for digital goods in iOS apps use in-app purchase and pay to Apple a 30% commission.
All right. Now, let's back up a little bit. When did you first have your earliest experience working with an Apple device?
Around 1983, I was 12 years old, and my father had given my family an Apple II Plus computer, which I learned to program on. That was my first experience with Apple.
And when did you found the Epic company?
I started Epic Games in 1991.
And when did you first have any app that you released through the Apple App Store?
Epic Games in 2010 when the iPhone 3GS had come out. When the iPhone 3GS came out with the first amazing 3D capabilities on a mobile device, Epic began making an Unreal Engine technology work on iPhone devices. We initially released a technology demo called Epic Citadel, followed by a first iOS game release called Infinity Mode, I believe in 2010.
So you said Epic Citadel and the next one?
It's called Infinity Mode.
Infinity Code.
Yes.
Thank you.
CLADD.
And between 2010 and 2020, did you perceive there to be any changes in Apple policies?
Yes, that was good. I'd initially been a fan of the iPhone model, but as time the policies became more and more restrictive. Apple continually ratcheted up the restrictions on developers through the policy statements and the enforcement of them. At one point, I think one of the things that made the biggest impression on me was when Apple introduced SearchGad, so that when a user searching for Fortnite saw an ad for a third-party game come up above the listing for Fortnite. That's a very severe frustration with Apple's approach.
If there were issues with Apple policies in 2010, or were there any issues with Apple policies in 2010?
I think they didn't initially take a critical view of Apple policies at that point in time.
Why did Epic wait until 2020 to sue Apple?
It took me a very long time to come to the realization of all the negative impacts of Apple's policies. And in particular, as in the very early days of iPhone games were built by a team of just a few people, and could reach a large audience and be very lucrative for developers. But over that period, as games and app competition grew dramatically, as the number of apps increased, there were many products being built by teams of 100 or more engineers for developers. The economic model had changed, which the average developer's profit margin in my experience was no under 30%. And so we got to a point where Apple was making more profit from selling a developer's app on the App Store than the developer typically was making themselves.
Mr. Sweeney, we'll just be asking sort of about your particular experience with regards to Epic. And let me just move on to the next question. In your view, has Epic been harmed by Apple's policies as they existed at the time this lawsuit was filed in August 2020?
Yes.
And can you please explain to the court how Epic has been harmed?
There are a number of areas. First of all, Apple is required use of in-app search reduces the quality of support that we can provide to customers. Epic doesn't have the ability to issue refunds to customers, and so if a customer has a problem, we can't service them directly and have to refer them directly to Apple, to talk to Apple instead. Also, Apple's imposition of this 30% commission is a really significant economic drag on the economic society. But there's an impact of Epic's pricing decisions. And that to the ability to reinvest less in our business than we otherwise would come over to the commission at present. And Apple's also imposed a myriad of policies on individual features of our products, which have restricted them from achieving this vision that we originally had for them, and in some cases provided us from doing things we did on other platforms with great success that were loved by customers. Yeah, so Apple's policies have in many ways prevented us from implementing the sorts of features that we wanted in Fortnite that we have been able to implement on other platforms.
Epic seeking damages in this lawsuit?
No, Epic is solely seeking changes to Apple's feature behavior.
Have you ever heard of the term special deal?
Yeah.
Is Epic seeking a special deal from Apple in connection with the filing of this lawsuit?
No, the remedy is that they seek to changes to Apple's behavior that would affect the entire market and Apple.
Is there any portion of the remedy that Epic is seeking that is asking for app review to go away?
No, with respect to apps distributed through the iOS App Store, I'm a supporter of Apple's freedom to review apps.
And is there any portion of the remedy that Epic is seeking that is seeking to have Apple's in-app purchase functionality go away?
No, I support Apple's right to offer a purchasing system to developers when they use the consumers. Epic is simply seeking the ability for other payment systems to compete with them at iOS. Service developers can choose freely among them.
And we're going to turn for a moment to Epic's business. Can you describe? The court, as of today,